Hello everybody, welcome back to our CMA classes. So we are going to resume our law class. Let's complete the remaining portion of inspection, inquiry and investigation. Okay, so let's go for it now. So 216 section says about the investigation of membership of the company. So who is having the power to do this? The central government is having the power either by itself, which is suo motu, or by the tribunal. Okay, on the order of tribunal, the CG will also go for the investigation of membership of the company. Okay, so CG shall appoint one or more inspector by order direct that the investigation into the membership of the company. Okay, the purpose, now what is the purpose of doing this? To determine the true person, first of all, okay, who are or have been financially interested in the success or failure of the company, who are responsible for actually success of the company or the failure of the company. Okay, next point says about the who are have been control the policy of the company, who are or have the policy control of the company, which means who have materially influence the company, right? The decision making power is with that particular person. Okay, who have or had beneficial interest in the share of the company. So for this purpose, which purpose? Actually to determine the true person who are having the influential power, material influencing the decision of the company, or who have the actual financial interest in the success or failure of the company. Okay, so in the section 216 says about the investigation of membership of the company, the CG will direct either by itself or the order of tribunal. The CG will go for the investigation of membership of the company. Let's go for the other section, which says the 217 procedure, power, etc. of the inspector. Okay, all officers, all the other employees and agent, which include the former officers, employees and agent of such body corporate. Okay, what have to do? These people have to produce the documents which is actually asked by the inspector. Okay, so to preserve and to produce all the books, paper, documents before the inspector. Take care. Okay, to give all the assistance which is in the connection with the investigation to the inspector. Okay, so duty of other body corporate is also same as this part, duties of officers and employees. Okay, let's go for the other point, which says about the period of retention of books of inspection is 180 days. Further 180 days would be granted extended if it is written in writing order. Okay, let's go for it now. The inspector shall return the books, paper and documents to the company, body corporate, firm or individual within 180 days. Within 180 days. Yes, the extension for the period of 180 days by an order in writing is possible, is granted. Examination and oath. The inspector may examine an oath on any other person, but before that they have to take the prior approval of central government. In that case only that would be allowed. Okay, in case of investigation under section 212, what was the section 212? Do you remember? SFIO, Serious Fraud Investigation Officer. Okay, yes, in this case when the examination and oath is taken, okay, by whom? The inspector. Okay, for that case the inspector have to take the prior approval from the central government. But in case of 212, in that case prior approval of director SFIO shall be sufficient. In that case they need not to go to the central government. Okay, an inspector may examine an oath in case of any other body corporate. Yes, all the officers, other employees, agent including formal officer, this applies to these people. Okay, they may ask for discovery and production of book of accounts or any other documents. Is it clear? These are the same thing which we actually know. Okay, let's go for the other. Summoning and enforcing the attendance of the person. This is also same. Inspection of any book, register and other documents of the company at any place, whether it is in the company or not in the company. If the documents, if the book of accounts and register which is related to the company for the investigation, if it is related to company, if it is kept any place apart from than the company, then the inspector have power to inspect that book of accounts, documents and etc at that particular place. Okay, let's go for the other thing. Now let's go for the punishment for the contravention, which says the fine. If director, officer of the company disobey, they are actually to find imposition in the section. ठीक है. First, if any director or officer of the company disobey the direction issued by registrar and inspector, remember earlier section 2 under 6 and 8, ठीक है. In that case, imprisonment up to 1 year would be imposed, ठीक है. But fine of 25,000 would be extended up to 1 lakh. Minimum fine of 25,000 would be imposed on that person, ठीक है. But it would be extended up to 1 lakh. Is it clear? Yes, ठीक है. They are this part. Now this is the another punishment for those people who have not actually given the information or have given the falsified information, have not cooperated with the inspector, ठीक है. So this part which I am going to read is punishment for those people. Let's read it. If any of the person fail without reasonable cause or refuses to give the information to the inspector, in that case, to produce to the inspector book of accounts, documents, to furnish any information which is duty to be furnished and actually it's not furnished, ठीक है. To appear before the inspection, okay, to sign the notes of any information. In that case, imprisonment up to 6 months. Imprisonment up to 6 months would be there, ठीक है. And fine of 25,000. This is the same fine of earlier, ठीक है, of officers and employees. This is the same part, ठीक है. Fine of 25,000 which would be extended up to 1 lakh. But there is one more point. For further up to 2,000 for every day after the first during which the failure or refusal continues. If that failures continues, ठीक है, in that case rupees 2,000 is going to be imposed on daily basis. Okay. So in this section we read that there are some documents or the procedure which is power of the inspector, ठीक है, which the officers, employees and past employees also, ठीक है, if they are in connection with that investigation, they have to produce, give all the information to the inspector. If they have not cooperated, in that case some of the imposition is to be, imprisonment is to be imposed, right, and fine, ठीक है. If that failure continues, in that case there are again 2,000 rupees imposition, ठीक है. And retention of book of accounts for 180 days and further 180 days would be granted if it is written in order, ठीक है. Hope this part was clear. So let's go for the 218 section which says about the temporary protection of the employees. What happens during the investigation? The inspector asks, investigate the all employees, right, which are actually engaged in the companies, ठीक है, company's activity. So what happens, some of the employees give the information related to those people who have actually done the fraud, ठीक है. DMAFS, do you remember, ठीक है. Yes, if any of the people, if any of the employee, if any of the officer is engaged in doing any of that activity which is actually making, you know, company in loss, ठीक है, or they are actually making altered, falsified or secreted any of the documents, in that case, and another employee of the company is giving the information to the inspector. In that case, what is going to happen? If the thing is known by that officers, that director or any other, the person who are having the power, ठीक है, they would take the advantage of their power. Which one? Like they'll either suspend that person, ठीक है, or take out from the employment, ठीक है. So let's go for it. There are some law which says about there is some protection given to those employees. We have given the information to the inspector, ठीक है. When the company intend to discharge or punish the by way of dismissal, suspension, reduction in rank, ठीक है, these are the actually things which are done by the person or the company, ठीक है, we're having the power with them, okay, or otherwise by way of change in term of employment of his disadvantage, who have given the information to the inspector. They are talking about those person who have given, those employee who have given the information to the company, ठीक है, sorry, to the inspector. So, okay, so when the company intend to discharge, let me read it again. When the company intend to discharge or punish by way of dismissal, ठीक है, or suspension, reduction in rank, or by any other way, by way of change in term of employment of that person, ठीक है, to his disadvantage. This section sees the protection to the interest of employee who disclose information to the inspector during the investigation proceeding, Hope this part was clear. So during the pendency of any of the investigation under section 210, 12, 13, 16 and 19, in that case, during the pendency of any of the proceeding against any person, connection is conduct and management of affair of the company under chapter 6, section 241 and 246, which is related to prevention of operation and mismanagement. Okay, we'll read it in next of our chapters. Okay, so for those people, the actually tribunal have given the protection to those employee. Okay, those employee will have given or disclosed the information to the investigator, inspector, to the during the inspection, ठीक है, or investigation, ठीक है. So before doing these thing, which thing? Dismissal, reduction in their post or suspension or any other change in their employment of that person, ठीक है. For in that case, the company cannot go without taking the permission from tribunal. Okay, let's go for it. Before discharging or punishing the employee, the company shall be application to the tribunal. If the company does not receive the objection from the tribunal, ठीक है, within 30 days, the company may proceed to take the proposed action. ठीक है, if the company want to suspend that person from the company, so they have to, before doing that, the company have to take permission from whom? From the tribunal. Okay, and that permission is, if it is not granted within 30 days, ठीक है, in that case the company can go for the action which they are going to take. ठीक है, तो they can go for the proposed action. ठीक है, the company is satisfied with the objection by then within, if the company is not satisfied, it is not, ठीक है, not satisfied within the with the objection, in then what can be they can go for the appeal to appellate tribunal. ठीक है, within 30 days the company can appeal to appellate tribunal. So what is the section saying? That the company, the employees, there is a temporary protection to the employee who have disclosed information to the inspector, ठीक है, while in the investigation and inspection. ठीक है, so the company either by way of dismissal, suspension, reduction in their post or change in some their employment, they can take these action. These are the action which can be taken by the company. ठीक है, so what happens in this case? The company can go for these action, but before they have to take the order from the tribunal. ठीक है, within 30 days, if the tribunal says you cannot go for these proposed action, in that case the company cannot go for it. But within 30 days, the order is not received, any of the order is not received by the tribunal. ठीक है, what is going to happen? The company can go for the proposed action. ठीक है, they can go for any of these action. ठीक है, any of these thing. ठीक है, but what if the tribunal have given the order within 30 days? ठीक है, in that case, and if this company is not satisfied by the order given by tribunal, in that case the company can go for further appeal in appellate tribunal within next 30 days. Okay, but what if the company is not again satisfied by the order of appellate tribunal? Can they go for further appeal? No, the appellate tribunal order would be final. Okay, and they cannot go for any other further appeal. Okay, that would be binding on the company. So order will be binding, final and binding on the company of the appellate tribunal. Is it clear? So 218 was of temporary protection which is given to the employees who have disclosed information to the inspector. Okay, let's go for 219. Inspector to conduct investigation into affair of the related company. Those we are talking about the subsidiary and holding company. Let's go for it. Inspected appointed under section 210, 12 and 13 consider it necessary for the purpose of investigation shall also investigate into the affair of any body corporate, take a corporate, which is or has that any relevant time being the company or holding company or subsidiary company of its holding. ठीक है, any other body corporate which all has its time management by position, managing director or manager who is or was at the time the managing director or manager of the company. ठीक है, any other body corporate whose board of director comprises nominee of the company or is accustomed to act in accordance with the direction or instruction of the company or any of its directors. Any person or has a relevant company managing director or manager of the company. Hope actually what is actually written in this section 219 says that the company which is the company where the investigation is done, ठीक है, inspection is done by the inspector, ठीक है, so the company which is related to that company, ठीक है, they are talking about the subsidiary and holding company, so the inspector can also go for the related companies, ठीक है, so inspector to conduct investigation into affair of the related. This section is particularly saying about that related companies and the related people of that related company, ठीक है. Okay, so let's go for the other section which says the search and seizure. Do you remember we also read about search and seizure in this chapter, ठीक है. So that was of search and seizure related to registrar, inspector, ठीक है. So let's read what is actually difference in these two sections, ठीक है. Section 220 says where the course of an investigation the inspector has reasonable ground to believe that the book and people of the company are likely to DMAFS, same है ना, ठीक है जी, which says destroy, mutilate, alter, falsify, secreted, can exercise the following power, ठीक है. 220 says about the search and seizure, ठीक है, of the book of accounts, ठीक है. The inspector can go for the following power if DMAFS have been done in the company by the people, ठीक है. Let's go for it. Actually this is going to be almost same as that section, ठीक है. So section which says the inspector can enter the place or places where such book on paper are actually kept, ठीक है. Seize book and paper as he may consider necessary, yes, ठीक है. Seize books and paper related to other body corporate or managing director or manager of the company, ठीक है. But there is only one point different which says the time period of retention. Earlier it was 180 days, right? Further 180 days were also provided extended, ठीक है, but it was to be in written order, ठीक है. But in this case time period is, let's read out, ठीक है, which says inspector shall be entitled to keep his custody the seized book and paper for such period but not later than the conclusion of investigation. So before conclusion of investigation, all of the book of account which was seized by inspector under section 220 is to be written back, ठीक है. So they cannot keep after conclusion of investigation. Hope so this part was clear to you. Now power of inspector to seize document before returning such, this is also the similar points, ठीक है, of which section you have to comment below now, ठीक है. Power of inspector seize document before returning such books and paper, the inspector may take copies, extract from book, paper, place identification marks on them, ठीक है. Now let's read out section 221 which says about the freezing of asset of the company on inquiry and investigation, ठीक है. What happened? The tribunal is having the power to freeze any book of accounts or any asset of the company actually, ठीक है, and that freezing cannot go beyond 3 years. So the freezing of asset of the company, ठीक है, is to be done for only 3 years. Let's go and read out. The tribunal is empowered to impose restriction upon the freeze the asset of the company. But can you tell me why the tribunal will go and freeze? Why would they do? है ना? Why would they go for freezing the asset of the company? Let's go and read out. Power of tribunal to impose restriction on transfer of fund and asset. The tribunal is empowered to make the order shall not take place removal, transfer, disposal of fund, asset, property of the company. Okay, this part is clear, ठीक है. The period during which the asset shall be subject to freeze and period shall not extend 3 years, as I told you, ठीक है. And there is some of the punishment for this contravention which says the company shall be punishable with 1 lakh rupees and extend up to 25 lakh, ठीक है. Earlier we did the punishment for the contravention were different, but in this section the punishment is different. ठीक है. 1 lakh minimum and be imprisonment for up to 3 years or fine of rupees 50 lakh and would be extended up to 5 lakh. ठीक है. So hope this part was clear to you. Freezing of asset is actually done by the tribunal. ठीक है. If they think that anything is doing against by the company or the director or the employee who are having the potential power, ठीक है, or they can change the evidence or they can make the manipulation in any of the documentation or asset of the company, right, to hide it from the inspector. ठीक है. In that case the tribunal have power to seize that. ठीक है. First of all, seize in the case of book of accounts. ठीक है. Second was of what I told you in this section is they have power to freeze the asset of the company for maximum 3 years. ठीक है. So let's go for the other part of this section, which says when can tribunal make an order. Reference made by central government. ठीक है. What I told you, when is going to the tribunal is going to do this. ठीक है. Freeze the asset of the company when the reference is actually made by central government. Okay. In connection with any inquiry or investigation into affair of the company. Okay. When complaint is actually made by the number of member. ठीक है. Under section 244 we'll read it. ठीक है. So complaint made by creditor. Okay. Having an outstanding amount of 1 lakh against the company. Only those creditor who are having the outstanding amount of rupees 1 lakh against the company. ठीक है. Complaint made by any other person. So when the complaint is actually made by these people, first of all central government member under section 244, ठीक है, and the creditor who are having outstanding amount of more than 1 lakh, ठीक है, and any other person, ठीक है, or any of the inquiry or inspection in affair of the company. In that case the tribunal may deem fit that the manipulation could be done or any of the asset can be means taken from this place to another place. ठीक है. In that case the tribunal can freeze the asset of the company for maximum 3 years. Hope so this part was clear. Let's go for the imposition of restriction upon the securities. The tribunal has power to impose the restriction upon the security not extend in 3 years. Punishment was 1 lakh to 25 lakh. Yes. ठीक है. Officer would be punishable 25 to 5 lakh. ठीक है. Imprisonment may extend up to 6 months. ठीक है. Let's go for the reports. Actually we know that interim inspector report under section 223 there are 2 reports. First is interim report and second is final report. ठीक है. Interim report when is made by definitely inspector, ठीक है, is to be submitted to the central government only if it is directed by the central government to do so. ठीक है. Otherwise need not to submit the interim report to the central government by the inspector. ठीक है. But in case of final report the inspector shall submit in writing to the central government. So let's read one more thing. Interim report. The inspector may submit the interim report in writing to the central government if it is directed by the central government, then only. But what about the final report? The final report is to be shall submitted to the central government in writing, ठीक है, within the time limit, ठीक है, prescribed. Okay. Copy of report of the inspector may be obtained from the central government by whom? Definitely members, definitely creditors, any other person who have whose interest is likely to affect. ठीक है. So this was about section 223. Let's go for the other section which says about the 224 action to be taken in pursuance of inspector report. ठीक है. So what are the action which is going to be taken by whom? ठीक है. Let's check out. From inspector report it appears to CG. Definitely I told you the interim report and the final report is to be submitted by inspector to whom? To the central government. ठीक है. On that report basis it appears to CJ that any person who is found guilty, any officer who is found guilty, ठीक है, or who is criminally liable, ठीक है, criminally liable, ठीक है, in that case the CG will prosecute such person for the offense, ठीक है, and the company would liable to be wound up, ठीक है. So first was that the CG would prosecute such person, which person who was actually engaged, ठीक है, who is actually guilty of any offense, ठीक है, who is criminally liable of doing that act, ठीक है. In that case CG will prosecute such person for the offense, ठीक है, for the offense. Hope so this part was clear. Second, the company would be liable to wound up, an application for claiming relief from operation and mismanagement. This was in this case, ठीक है, in this case only, ठीक है, the company would be liable to wind up. Next, recovery of damages can be asked by that person who was guilty, ठीक है. So recovery of damages in case of fraud, misfeasible misconduct in connection with promotion or formation or management of affair of the company, ठीक है. In case of fraud, misfeasible or misconduct, the recovery of damage is to be taken from that person, ठीक है, who was actually engaged in promotion, formation or management of affair of the company by these, ठीक है, fraudulent activity, ठीक है, by these fraudulent activity. In that case, ठीक है, recovery of damages is taken, company would be liable to wound up under section under operation and mismanagement, ठीक है. Yes, and one was prosecute that person for offense, ठीक है. Okay, so this was the end of this chapter. Hope you understand a bit, ठीक है. Do your revision regularly and we'll meet again, ठीक है. And we are going to start our new chapter which is going to be compromise, arrangement and amalgamation, ठीक है. Till then, today's guys, we'll meet again. Hit the like button if you like this video, subscribe my channel. Today.